beautiful friends. What an amazing day it is. Welcome back. I hope you have returned from your Labor Day celebration restored and bursting full of energy. We've got a great stream planned ahead today. Quick preview, and then we'll zoom in for further detail. But here's what's coming up. We've got a bunch of stuff happening today. We're going to start out by going over to a D.C. Circuit Court of Appeals decision that is giving the old legal proverbial backhand to this judge right here, Judge Tanya Sue Chutkan. We remember her from the January 6th prosecution against the president, and what a rigged case that was. Well, she made another adverse ruling to Trump, and now she's been reversed. And what's so fun about this is she had some discretion in this decision, and they say she abused it. So abuse of discretion is the standard, and she met it, and now she's getting reversed. And so the American taxpayer is going to save something like $16 billion or something like that. Lee Zeldin is very excited about it, and we'll go through the news. Big win, and of course, it can go up. It can go to the full panel on the circuit court. But as it stands, nice victory. And the logic is sound, and it comports with the same things we've talked about here. You're filing in the wrong court. You can go complain about your canceled money, but you can't call it a constitutional crisis or due process problem or whatever. Go file your claims in the proper court. So we'll go through that. Then we got to talk about this woman. Her name is Nath Jones or something. And she's on Instagram or X or Facebook, whatever, at nath.jones, and she was arrested, and there was a complaint with an arrest warrant that was filed against her. She posted some insane things on the interwebs, like what? Somebody's trachea, okay, coming out of their throat. Not good. It needs to stay in your throat. So we'll go through what the criminal complaint is against this woman, but the real shocking thing, people say a lot of crazy things, is that the judge who released her out of custody is a very interesting judge who we know right here, Judge Boasberg. So we'll go through it. We'll see what's happening. We'll see what the conditions are, whether she's got any criminal history or what's going on. So we'll see what the latest is on that one. Before we turn our attention, man, we got trial coming up, starting with jury selection in less than a week on Monday. Ryan Routh, the attempted Trump assassin, is going to be on trial. And he's submitting very interesting motions in his defense. Remember, he fired his attorneys, and now he's going to be representing himself. And, well, today was the final pretrial conference, and he sent in a couple of motions. You can see one of them is here, saying that he might want to subpoena the baboon Donald Trump. It's going to be his legal strategy. All right, well, we'll see what's going on there, because the government has, I think, a little bit more robust strategy. They just released their exhibit list, and I have that queued up somewhere. Final tab I click, of course. And they got a lot of people coming in to talk about this. So we're going to have a full trial underway next week, and we'll get up to speed on what the latest is on all of that in our trial prep work. And so it's going to be a great stream, my friends. Thanks for being here, and thanks for being supporters of our channel. Thanks for subscribing. Thanks for becoming members. We had a great members only stream this morning where we talked about what's going on over there in England and how epping mad they are, rightfully so, sending out our love and wishing Godspeed to our fellow Englishmen who are just trying to reclaim their country that's been stolen from them, from their own people. Anyways, we talked about that this morning. It was a good stream. And we'd love it if you became a member. We're going to do an after party today, so stick around, membo. Stick around after the show. YouTube friends, you'll get a new link. Locals friends, hangs tight, and we'll see you there. Now, without any further delay, let's dive right in, because we got some serious briefs to read today. Starting here. Massive victory for the American taxpayer and a big reversal for everybody's most complicated judge. Judge Tanya Chutkan. Well, this is the case brought by individuals suing the Trump EPA saying, we want our money. You can see the Climate United Fund sued the EPA and Lee Zeldin, and they've just lost today bigly. Now, I'm sure they're going to reappeal it, so it's not totally conclusive yet, but it is progressing through, and today was a major victory. And so Lee Zeldin is celebrating. He says, massive DC Circuit Court win for the Trump EPA and the taxpayers. After the Biden EPA set up the Greenhouse Gas Reduction Fund, whatever that is, through self-dealing and conflicts of interest, unqualified recipients, and reduced agency oversight, I terminated these grants completely. And they flipped out. They said, we're entitled to that money, and it's like billions of dollars. And you remember that Stacey Abrams got like $2 billion of that, part of one of her funds. Now, she didn't get $2 billion personally. And a lot of the fact checking out there says, well, Stacey Abrams didn't get $2 billion personally. So stop saying that. Okay, well, she's on the board. She controls the money. It's going to her. They had no background or real budget at all, as we'll hear, but they wanted the money anyways. And it was just the Biden administration just dishing it all out at the last minute because they were ransacking the Treasury, of course, opposed to the American people. And so this was a big victory here. You can see the judge who is getting reversed on this is Judge Tanya Sue Chutkan. She was the January 6th judge against Trump. And we've largely viewed her as being very anti-Trump. She was an Obama-appointed judge, and we've talked a lot about her. And she's made some bizarre rulings that are very anti-Trump and America, in our opinion. So she is getting reversed, and the court is basing the reversal on an abuse of discretion standard, saying, you should have known better, Judge Tanya, but you didn't. And here is what the decision sounds like from the District of Columbia Circuit Court of Appeals, reversing Judge Tanya Chutkan in the case of Climate United versus the EPA. And remember, Citibank is where all that money was being stashed until the EPA went and got it back. And so here's what the judges said. So it was just the circuit judges. This might go up for en banc, right? So they might appeal this to the full DC circuit, and they're going to delay the implementation of this order for a week. But this is still the decision coming out of the court. They write, courtesy of Judge Routh, the EPA awarded grants worth $16 billion to 5 nonprofits to promote the reduction of greenhouse gas emissions, which is great because I don't know if that was like $16 billion to just stop Stacey Abrams from speaking or what. Citing concerns about conflicts of interest and lack of oversight, the EPA terminated the grants in March 2025. Thank you, President Trump. Now, the grantees sued, and the district court, Tanya Chutkan, entered a preliminary injunction ordering the EPA and Citibank to continue to fund the grants. Okay, Tanya's dishing out the cash. Here you go. Have some more greenhouse reduction gas money. Go reduce some greenhouse gas. Yeah, we conclude the district court, Judge Tanya Chutkan, abused her discretion in issuing the injunction forcing Trump and the American people to pay them. The grantees who got this stolen money, in my opinion, are not likely to succeed on the merits because their claims are essentially contractual. Oh, and therefore jurisdiction lies exclusively in the Court of Federal Claims. Okay, it's not a constitutional crisis. Your livelihood is not being stripped away from you illegally. You had a contract with the government, and guess what? It's canceled. And while the district court had jurisdiction over their constitutional claim, that claim is meritless. You can file a constitutional claim, but it has no basis for being here. It's a contract problem. So go file it in this Court of Federal Claims, which has literally been set up for your exact type of complaint by Congress. We are divested of that. Now, moreover, the equities here strongly favor the government, which on behalf of the public must ensure proper oversight and management of this multi-billion-dollar fund. And so accordingly, we vacate the injunction. And that is a nice development. And we're all asking this question. We've been asking it for months now. What is Congress going to do about this? How many times do they need to hear abuse of discretion, abuse of discretion, abuse of discretion? We're getting tired of saying it. Here's another one. And Judge Tanya abused her discretion many times over. Okay, she accelerated Trump's J6 case. She rigged the discovery process. She allowed page limit exceptions and motions to be filed completely out of order to have maximum consequence for the general election because they knew they weren't going to get a trial. So then she's like, well, Jack Smith just filed a bunch of motions. And he's filed a bunch of motions to try to smear the president. It was all a sham. It was a rigged trial, okay? And Congress just sat around twiddling their thumbs, probably hoping that many of them, that Trump would be taken out legally and maybe more, and then sat on the sidelines and did nothing about it. And now we're here. Now we've got Jim Jordan, and now we've got Chuck Grassley, and these two guys who are running the judiciary committees, and they're not even opening inquiries or even mentioning the I word. They don't even want to talk about it. Nobody's even asking them about it. What about impeaching the judges? They're abusing their discretion, okay, again and again, and there's a pattern. And Gorsuch said that they violated the Supreme Court order 3 times, and he had to come down there and scold them over it. So what are they doing? Is this not enough? What else do they want? Some judge to let an illegal alien use their back door? I don't know. All right, now we've got more. Now, the case from the D.C. Circuit Court of Appeals says this case involves EPA grants, which were awarded under the Greenhouse Gas Reduction Fund, which is, I mean, we were just getting so ripped off. It's insane. $27 billion for a greenhouse gas reduction fund, which might be, you know, I mean, human beings produce CO2. Do they call that greenhouse gases? I think they do. Now, in August 2024, EPA awarded $20 billion to 8 nonprofits pursuant to 2 of the grant programs that it created. They call it the National Clean Investment Fund and the Clean Communities Investment Accelerator. Okay, the liberals have some of the dirtiest, grossest, disgusting cities in the entire planet. There's crap all over the streets in San Francisco. So maybe they should focus on that. 5 of those grantees are now suing. They all said, we want our money. Climate United Fund, $7 billion. Coalition for Green Capital, $5 billion. I mean, they're billions of dollars. Like, the amount of money is just unfathomable, and it's just like urinated out to everything. Power Forward Communities, $2 billion for that. And Inclusive Inc., can't even spell the word right, they got $1.8 billion. And the Justice Climate Fund, almost $1 billion. And it's just, you know, ransacking from all of us. And it costs, I mean, it costs us something. It's not just free money. Everything is expensive, and it's because our own politicians have been ransacking our finances. Each grant was memorialized in an agreement, like a contract. The grant agreements have an unusual structure. Typically, grant funds are held by the U.S. Treasury and dispersed incrementally as grantees use the funds for the program purposes, whatever. EPA structured these grants with a middleman that would hold the funds as a financial agent of the United States. Now, according to the EPA, this was the first time the government used a financial agent because they wanted to get rid of the money, okay? Because they know that if the money stays with the Treasury, the next guy has control over it. So if they divest it to a third party to act as basically the broker or the escrow, then that's good, right? Because then the government can't come claw that back, as opposed to the Treasury to carry out this kind of program. Now, Treasury entered a financial agency agreement with Citibank, and they were going to hold the funds. As set forth in the grant agreement, if the funds were to be transferred, they were to be transferred from Treasury to Citibank in a 2-step transaction, and then there'd be a drawdown, and they'd go to the bank and just say, can you re-up our credit card, please? A lot less oversight responsibility, too. So although the funds are held at Citibank, the grantee's use of the funds remains highly restricted, I'm sure. The money may be used only for the purposes and under the conditions of the grant agreement and must be maintained at Citibank until the end of the performance. And it gives, this is important, the grantee's use of the funds is further restricted by account control agreements between the EPA, Citibank, and the ACAs give the government a right to exclusive control over the Citibank accounts if they want it back. If the government exercises that right, Citibank must follow the transferee instructions and send it back. And they must do it without further consent by the grantee. Okay, they don't get to object and stop this money from coming back. The ACAs, the agreements, expressly acknowledge that Citibank acts as a financial agent of the United States and the Department of Treasury. So if we want it, it is our money. Now, the sheer scale of the grant program, thank you for saying that, Judge. It's insane. And the method of allocating billions of dollars drew public attention and criticism, yeah. The record includes a widely publicized video in which an EPA employee was recorded describing how, quote, until recently, he said, until recently, His role was to make sure that proper processes are in place, to prevent fraud and abuse. But after the election of Trump, the EPA was just trying to get all the money out as fast as possible before they came in and stopped it all. All right. So they were unloading the money. They're like, Trump's going to win. He wins, just shoveling it out, just throwing it out the back of the window. The employees compared the situation, to throwing gold bars off the Titanic. Okay. And that's our money. This is like theft, and so I hope there's a lot more to this. Who was doing that? Who was violating the law? Did the law say you can do that or not? So who broke those protocols and those procedures in violation of the directives that the law mandates? And where did it happen in the Biden administration? And they hopefully are investigated. The month before Trump's inauguration, EPA modified the grant agreements. They just changed it with no apparent consideration for the grantees. That means the grantees aren't really putting skin in the game. All right. They're getting a benefit without having changing anything. So like you enter into a contract. Okay, these are the agreements. You say, well, we're going to modify the contract. Now we're going to, change these things. Usually both sides are, getting something. There's an exchange. Oh, you're going to give up this right, or you're going to get this right, or you're going to get this money or this asset or whatever. There's some consideration. It's not just a gift because there's some sort of exchange of value for that in broad terms. And so they didn't do that. The grantees are like, oh, so you could have taken it back from us and now you can't. And we didn't have to do anything different. Well, that's great. More rights for us. So the judge says there's no consideration for this. Like, why did they get that extra benefit? To make it more difficult for the government to terminate the grants. In fact, in December 2024, like days before Trump's coming in, the government unilaterally modified the grant agreements, these treasonous monsters, including by eliminating any reference to termination for agency priorities. They changed the deal, requiring credible evidence for a violation of federal criminal law before the government could terminate anything. Okay, so they like tightened it up. It used to be you could terminate for whatever. Now you can only terminate if there's a criminal violation. It's the only thing you can do. So you basically got to charge somebody. And they wanted to give the grantees an expanded right and inauguration, expanded right inauguration. EPA amendment, what the heck is going on over here? Yeah, all right, interesting. And to require Citibank to continue to disperse the funds. Now, after the change in the administration, the EPA reviewed the grants and raised concerns about conflicts of interest during the awards process. The political connection of the chosen grantees like Stacey Abrams. Lack of government oversight and control over tens of billions of dollars. Last-minute amendments to the grant agreements and the contracts. It's all just by criminals. In February, the FBI, like imagine if you were doing this at your private company, like you're quitting and you're like, we're just going to unload everything. Some people do that. They quit. They take all the, all the staplers and all the extra paper. Oh, the printer toner. You're going to take the toner with you. Okay, on your way home. Great. Okay, nobody prosecutes them for those things. All right, whatever, be gone. That's why we fired you. But this is like ransacking, right? Like, if you're in a corporation and the board ransacks everything at the last minute, you kind of get Enron and everybody gets pretty upset about it. But if it's the Biden administration and if it's Stacey Abrams and all these green lunatics and they're getting billions of dollars, it's all just kind of, policy. Now, in February 2025, the FBI recommended, so Trump comes in, now changing of the guard, they're throwing gold bars over the Titanic. FBI recommended to Citibank that it placed an administrative freeze on accounts associated with the grantees. You're not getting that money, Citibank, remember? And they all freaked out. They sued. As the government's financial agent, Citibank said, okay, Trump's here. They complied. They stopped dispersing the funds. Thankfully. EPA also referred the matter to the Office of Inspector General for investigation. Let's go. That's what we like to see. Shortly thereafter, the EPA terminated the grant agreements. Yeah, because there are a bunch of criminals, man. This is rotten. There are people in here rotten top to bottom who should be prosecuted, I would imagine. Now, we're kind of speculating on that. But even the judge is going, what the heck? And this is all last minute. And you've got witnesses saying gold bars over the Titanic. All of our standard protections are being ordered around. The grantees sued. We want our money. You can't take it from us. This is unlawful, arbitrary, and capricious, even though all of their changes were exactly that. They sought a preliminary injunction stopping them from terminating the grants and forcing the money to go out. And guess what happened? Judge Tanya Chutkan, the J6 judge, she entered the injunction. She says, pay them. She held that it had jurisdiction, Tanya said. The grantees' claims were not essentially contractual, and therefore they didn't need to go into the appropriate court. Okay, contract claims, again, there's a lot of contracts with the federal government. If every time there was a contract that was breached and the breaching or the non-breaching party was filing claims in federal courts saying, my constitutional rights have been violated, the government canceled my contract, we would have lawsuits out the wazoo and we never get any business done. So Congress created the Court of Federal Claims. You got a claim against the federal government? File it over here. We'll see you over there. But Tanya Chutkan said, no, this actually isn't a contract claim because it's like the climate and everyone's going to die. And so they had basically a right to that money. And if you're taking away a right, then you need due process. You need a constitutional rationale to do so. So on the merits, the court, Tanya, who is getting reversed aggressively right here, concluded the grantees were going to win. In her illiterate analysis, she found that the balance of the harms, okay, and this is it, this is policy. They care more about policy than the law, and they use the law to effectuate their policy. She supported an injunction. She says, because the nonprofits, they exist, and there are already sufficient protections to prevent reckless spending. Okay, so it's all good. And they're existing. They're going to fulfill the objectives of the grant. I have no idea what this has to do with anything. And sufficient protections are in place to prevent the reckless spending. So it's like her judgment is better than the president's. Now, the district court further concluded that an injunction halting any unlawful action, all right, can you define that? Serves the public interest, and the court stopped Citibank as well, enjoined them, requiring them to disperse the funds. So you're stopped from following Trump's orders, give them the money. Now, DC Circuit says, all right, look, we stayed her injunction. We said, no, you don't have to continue to dish out that money pending the appeal. And we ordered everybody to just stand by, thereby prohibiting the grantees from making further commitments in reliance of the disputed funds. And now we accelerated all of this to get to the merits of this case, and here we are. Now, while this litigation was pending, Congress also enacted legislation repealing the Greenhouse Gas Reduction Fund. Our partial stay did not lift the portion of the orders enjoining the grant terminations, so the funds at issue in this case remain at Citibank. And they remain obligated, right? So the greenhouse reduction, like this is already money that's out the door. So this did not render the appeal moot. Okay, so like that money is still there. It's still accounted for. So we review Judge Tanya Chutkan and we ask, did she abuse her discretion? And there are these different standards, right? Just like we talk about when you're prosecuting somebody, there's different standards, and beyond a reasonable doubt is the burden of proof that we ask, is that met in order to convict somebody of a criminal charge? Or you hear other standards like preponderance of the evidence, right? 51% more likely than not, preponderance of the evidence says you committed this traffic infraction. And so that stands. Now with judges, the question is, did this lower judge screw up? Is there a clear error in the law that they just made a mistake on? Is it a clear error? Are they looking at it de novo, which means we're going to look at it fresh with a fresh set of eyes? Can we only reverse it when there's an abuse of discretion standard, right? And that's as things start to escalate up to abuse of discretion. You had a judgment to make. That's what this is. You're a judge. Your whole job is judgments. You have discretion to make judgments, and you abused it. Tanya Chutkan, blown out. Now, here is what they write. We consider the same winter factors that Tanya applied, but we analyze it intelligently. The district court, Tanya, she erred in concluding that the grantees are going to win. She said the likelihood of success was based on was the most important factor. Now, the grantees' regulatory and their claims can only be heard in the Court of Federal Claims. So, Tanya, you're totally wrong. Like, jurisdictionally, you're not even close. Their constitutional claim also is meritless. Now, let's get into it, because the grantees, their first allegation is that the terminations of our money was arbitrary and capricious under the APA. And so they sought money. Now, what happened is, Court of Appeals now reversed. We conclude that Tanya Chutkan lacked jurisdiction over these claims. They are contract claims. They have to go to the Court of Federal Claims. Here's why. The federal government enjoys sovereign immunity and may be subject to suit only when it has explicitly waived that immunity. And waivers of sovereign immunity must be strictly construed to protect the prerogatives of the government and to ensure courts stay within their jurisdiction that Congress mandated for them. The grantees brought their claims in district court, invoking the APA's waiver of sovereign immunity, which applies to claims seeking relief other than money damages, okay? They're saying it's not just money. It's not just a contract. It's our entire, existence. And so we need the money in order to survive. And so it's not just money. It's also something else, is how Chutkan interpreted it. But this waiver only applies if no other statute that grants consent to the suit exists. And we have that. For contract claims against the government, the Tucker Act establishes review in the Court of Federal Claims, and that may award only damages and cannot provide any injunctive relief in narrow circumstances. Okay, so they just say, well, you're entitled to this money. So, okay, yeah, get the money, but don't continue the granting, the exercise of the grant, which might have more money coming. So although, there's a footnote here, although the dissent considers this jurisdictional question a diversion, our authority depend on jurisdiction. Concluding that jurisdiction over most of these claims lie within the Court of Federal Claims, we're not even going to reach their merits. Now, the dissent inverts this fundamental limitation on the Article 3 courts. You only have jurisdiction, cases in controversy in your jurisdiction. The dissent inverts all of this, recounting at great length the integrity and the virtue of the previous administration's efforts to implement the Inflation Reduction Act, which created massive inflation for everybody, and the alleged misdeeds of the current administration. So it sounds like the dissent was just like a blog post. I don't know, probably like Ketanji or somebody was influencing that. Our jurisdiction, however, rests on law, not on the severity of the alleged wrongdoing by the grantees and the public policy, right? So they're wrecking the dissent as well, saying when it applies, the Tucker Act and the Court of Federal Claims are exclusive. And the inquiry about jurisdiction cannot turn on how the climate changers want to characterize their claim. Of course, they're going to say it's not a monetary claim. They're going to say, no, it's a constitutional claim, our due process right. Everybody's going to make that claim. And so the standard can't be, well, it's just whatever they say. To determine whether we have proper jurisdiction, we must therefore assess whether the grantees' claims are essentially contract claims. Now, they first say that no, the termination of their agreements violated regulations. So they can't terminate these things. And they didn't provide written notice, and we have contractual disputes and more. They say, look, the source of their right to the relief they seek are in the Tucker Act. Now, each grantee's rights to the funds arises only upon creation and satisfaction of a contract. It's necessary to get the money. It's around a contract. If there's no contract, there's no money. While the grantees attempt to ground their claims, they say, no, we're not actually complaining about the contract. We're complaining about the cancellation of the contracts because they are exercising improper power to cancel the contracts. It's okay, but you're still talking about a contract, right? They claim the EPA violated the Code of Federal Regulations. And they interpret this as prohibiting the government from terminating their grants except with proper permission. Even assuming this is what the guidance requires, the grantees' claims turns on the government's rights under the agreement. And this is in fierce dispute. Because this claim perforce incorporates the agreements, it is not based solely on the regulation or on other truly independent legal grounds. It's a contract claim. Now, the claim that they failed to give proper notice, they said, well, it's a due process problem. I didn't get notice of our contract cancellation. That's not an independent legal ground for a slightly different reason. This allegation could be phrased, quote, as a claim that the government stopped performing on the contract without sufficient warning, right? Another contract dispute. Federal contract law already addresses that. Contract law talks about notice of cancellation. So the Court of Federal Claims can hear that too. And furthermore, the guidance documents on which the grantees rely do not create enforceable private rights, okay? Just because you got billions granted to you by the corrupt Biden administration does not mean you now have a property private interest right in that money. It's a grant that can be revoked. These guidance provisions fall within the law and the guidance. And second, the Court of Federal Claims, by the law, has exclusive jurisdiction because the remedy they want is, again, contractual. They want an injunction. They want the EPA not to terminate the grants. They say, we own the funds. They're ours. And they want an injunction barring unlawful interference by the American government, rather than an order for specific performance. But their, quote, ownership of the funds goes only as far as the grant agreements are and the terms of the deals. And the funds are held by Citibank, which is a fiduciary of the government. So despite their characterization, in substance, these climate changers are seeking specific performance of an agreement with the government. As then Judge Scalia, rest in peace, said, the waiver of sovereign immunity in the APA does not run to action seeking declaratory relief or specific performance in contract cases, okay? We don't hear these claims. And so in sum, the Stacey Abrams people cannot manufacture jurisdiction. They can't make it up through artful pleading by just saying, well, we're not complaining about the contract. We're complaining about all of the mechanics that resulted in the cancellation of the contract. So we can sue here. And they're doing this intentionally. It's forum shopping, okay? They're going to Judge Chutkan, to Boasberg, to Zenas, and they're doing the same thing. And they're getting them to effectuate their public policy to stall out the Trump administration. And Congress should do something about it. Because the grantees' claims are essentially contractual, they must be heard in the Court of Federal Claims. Nor can the grantees repackage their contract claims. Their arbitrary and capricious claims are also contracts. They say, well, the government acted arbitrarily because it offered no facts or reasoning to justify the terminations. Yeah. And the grantees insist, well, we can challenge the government's reasons. It's not a good reason. And that should be separate. But this court has expressly and repeatedly rejected attempts to manufacture jurisdiction by just calling it arbitrary and capricious. As already discussed, they seek to set aside their grant terminations. It's a contract. And so the APA doesn't allow you to sneak in contract claims through that provision of the law either. Now, to the extent they argue that these were arbitrary, they can make those claims in the appropriate forum. The grantees insist the APA gives them an independent right to sue, and they say, yeah, in the Court of Federal Claims. And so in sum, district courts, writes the Court of Appeals, this is great, have no jurisdiction to hear claims that the federal government terminated a grant agreement arbitrarily or with impunity. No jurisdiction from the DC Circuit Court of Appeals. Huge line. Claims of so all DC judges, you're on notice, okay? All of these little piddling lawsuits coming in, suing the Trump administration, saying, you can't sell that money, you fired us, you can't do it. They're contract claims. Go get a new job. Go file it with the Merit Service Protection Board or the Court of Federal Claims. Claims of arbitrary grant termination are contracts, okay? They fall outside the waiver of sovereign immunity and you cannot sue. So this conclusion is also reinforced by the Supreme Court's recent decision that a very similar case brought with a similar claim. In that case, they sued the district court and they said the Department of Education can't cancel money. The court stopped the injunction, said the district court lacked jurisdiction because it should have been brought in the appropriate court. And the reasoning requires respect from the Supreme Court and strongly supports our conclusion that the arbitrary and capricious challenges are without merit. And in the face of this overwhelming authority, they still say you have jurisdiction and that it's proper. They give us these two cases, and these cases are obviously wrong. These are contracts, writes the judge. In short, they cannot circumvent. There's a whole other court. You can't bypass it just because you're mad. Finally, the grantees cannot bring their regulatory claims or arbitrary capricious claims by arguing they acted outside the law. The Supreme Court recognized those types of claims are limited. You cannot bootstrap another claim to try to create jurisdiction. And they also say there was a separation of powers problem here. They say, well, Congress said we have to get this money. They say you're going to lose that claim too. As an initial matter, this isn't a constitutional claim at all. They say, well, yeah, it is. It's a separation of powers. Congress said we want the money. Executive branch is like now not giving us the money. So violation? No. Claims that agency officials acted in excess of their authority are not ipso facto violations of, quote, separation of powers. What are you talking about? Here we conclude they didn't violate the Inflation Reduction Act when they terminated those grants. The grantees have identified no statutory provision that barred the cancellation of the grants. In the relevant part, the Inflation Reduction Act appropriated $20 billion to make grants on a competitive basis, saying that funds are to remain available until September 30th. Clock is ticking. That's why they wanted that money so quick. The grantees interpret these provisions as a mandate that the EPA must spend the full $20 billion. A mandate that they say they violated. But even assuming the statute required the EPA to obligate $20 billion by the deadline, they did so. And they later canceled the grants, but the act does not limit the discretion to terminate the grants. So they complied and terminated. The EPA repeatedly represented that it planned to recommit the funds. So it's not going to you people, but it'll go to someone else. Now, the grantees and the dissent, they say that the promise to recommit those funds was hollow, and we're not going to get any money. But they cite no authority that any recommitment has to happen under any particular conditions. In fact, this happens all the time. The executive branch often issues replacement contracts after terminating contracts regularly. We've got a long-standing practice of doing this, and so we're not going to force this to change. The district court's determination, Judge Tanya, who got reversed, that the grantees were going to win relies on both factual and legal error. Oh, Tanya, how'd you screw it up so badly? Factual errors, legal errors, abuse of discretion. Hopefully Jim Jordan's listening to this. The factual determination was not supported by any evidence in the record, okay, and rested only on her assertion that the EPA suspended all 8 grants. So now Tanya's just making stuff up. What? But the suspension of the grants, standing alone, cannot demonstrate that the EPA was shutting down these without congressional approval. Instead, the EPA repeatedly stated that it planned to recommit the money. And so there's no evidence to the contrary of that. So the EPA was entitled to a presumption of regularity because it's the government. You give them the benefit of the doubt. But rather than credit the statements, Tanya simply declared the EPA was shutting down the programs. The court disregarded the government's interest, didn't even consider it, because what does Tanya care? She hates the government, Trump now, and loves the government when it's her government, but hates it when it's in service of the American people. In prudent mismanagement and to properly supervise, the district courts totally screwed up, and her conclusory factual finding of the program dismantlement was clearly erroneous. Even an 8-year-old could see that, Judge. Because the EPA issued the grants in accordance with the IRA, and there was no evidence they sought to dismantle anything against the law, they can't say that they're violating anything. The EPA's actions here are well within the authority to manage the expenditure of funds. The grant terminations may be challenged on the merits, and they can sue in the other courts. And the loss of grant money, stop crying about it. It's not irreparable harm. You said that, Tanya, that it was going to be irreparable harm because the purpose of their businesses are going to go away, essentially. But they don't fall into this exception, okay? Nonprofit entities that may need to suspend operations that were created solely for the purpose of these funds may exist. And while their existence relies on grant money, as Tanya said, they're going to die if you don't give them federal. Then maybe they shouldn't exist if all they do is just take government money and don't produce anything useful as far as we can tell. Creating such an entity cannot establish an irrevocable claim. Okay, so you get money, you just form a nonprofit. The nonprofit exists because of the money. Now you can't take the money away because of the nonprofit. This is a threat. It's not irreparable harm. They made up the business so they can go make a new one. The EPA terminated the grants because of concerns about the integrity of the grant-making process, which is a very real concern. While litigation is pending, the grantees may have to scale down their operations. Now, although this causes some harm, the harm is readily compensable through damages, and therefore it's not irreparable, okay? If their claim is that we're losing money and we're going to die, well, that's great. In the Court of Federal Claims, do you know what happens if you win? You get money. So go over there. They'll give you exactly what you're looking for. So the balance of the equities in the public interest favors the government. The injunction that Tanya did harms the government, and it harms the public interest by preventing the executive branch from properly and prudently managing billions of dollars. The grantees have an interest in the continued access to government funding, but the government and the public have a stronger interest, thank you, Judge, in protecting the public. Fisc and eliminating the appearance of impropriety around these grant programs. And moreover, if the grant terminations are later determined to be a breach of contract, the government's going to have to pay damages, and probably a lot. And Congress set up an explicit mechanism for this over in the Court of Federal Claims. And so the same considerations support vacating the injunction as to Citibank as well. And so for the foregoing reasons, we vacate the district court's injunction and remand the case back down to Tanya for further proceedings consistent with this opinion. So she's going to have to, live with herself tonight, recognizing that the Court of Appeals just said that she was clearly erroneous, abused her discretion, and made factual and legal errors, and got reversed from the District of Columbia Circuit Court of Appeals. Happy to see it. We're going to save some serious money on that. And this is a video from EPA Director. This was a while ago, a couple months ago, but he was talking about this case and said Stacey Abrams' money is getting withdrawn and retracted. Here's what he said.
At the Trump EPA, the one big beautiful bill was filled with many big beautiful wins for the taxpayer. It delivered a sledgehammer to the Green New scam. Billions of dollars rescinded. So it's a big deal for the American taxpayer who sees money go through pass-throughs that are filled with self-dealing and conflicts of interest. They see unqualified recipients. They see reduced agency oversight, and they want accountability with their tax dollars, and they got it. So in the example of the Stacey Abrams connected NGO, they received $100 in 2023. They got $2 billion in 2024. They had to complete training on how to develop a budget that was put into their grant agreement.
Crazy.
They, out of nowhere, started paying a CEO $800,000, a COO $450,000, 22 people making over 150 grand. Out of nowhere, this is tax dollars. So money go through pass-throughs, through other pass-throughs, through other pass-throughs, and we lose oversight over it. And you see that it's going to former Biden officials, it's going to former Obama officials, it's going to Democratic donors. And we're not here saying we want to take money from a left-wing NGO and give it to a right-wing NGO. We want to give it back to the taxpayer. This is about us being good stewards of American tax dollars without any apology or regret. That's why President Trump was elected last November. Because there were a whole lot of people who maybe they hadn't voted Republican in a long time. Maybe they didn't even vote for President Trump the first time around in 2016, but they're regretting that vote from 2016 and they were making it right in 2024. So the one big beautiful bill gave us the tools to rescind billions of dollars more. We're seeing hundreds of thousands of dollars that'll get wasted per electric vehicle as an example of this money that was going through it. They gave $50 million to a group called Climate Justice Alliance. They say that climate justice runs through a free Palestine. The Biden EPA gave $50 million to a group that says that climate justice runs through a free Palestine. We say that if you're going to spend $1 in the name of remediating an environmental issue, then spend the dollar on remediating an environmental issue. We say that we can protect the environment and grow the economy. We want to help grow more baseload power in this country. So why is it that it took this long for this team to get assembled, to be able to fix the mess that we inherited. But gosh, we love showing up at our jobs every single day, first thing in the morning, because all day long we get things done for the American taxpayer. And Congress did its...
And they did, baby. So big victory. Lee Zeldin celebrating. The DC Circuit Court of Appeals issuing a massive decision, and hopefully the rest of the panel agrees. Now, the decision will be stayed for, I believe, 7 days, and no doubt about it, these climate change nonprofit public servants will absolutely appeal, and we'll see what the DC Circuit says with the full panel. But this is a nice decision. The logic is sound. It is reflective of what the Supreme Court has already said. And hopefully this is the start of some sanity in some of these courts, because this was a message to the other district court judges in DC. You can't entertain these claims anymore, or you're going to get the legal proverbial backhand. All right, now let's carry on, my friends, because we got some other news to attend to. And here's this one. We've got a story about this person. An anti-Trump TDS Wacko was just released out of custody after posting some pretty horrific social media posts. You're looking at one of them. We'll hit the highlights on what she said, but this comes out of a complaint, a criminal complaint filed against her for criminal charges. And this is taking place in the District of Columbia. You can see there was an arrest warrant that was issued for this woman, Nathalie Rose Jones, and the court judge who originally got the case at the lower level, the magistrate judge, is Mokshila Upadhyay. And we've talked a lot about her as well, because she gets a lot of these cases coming through. And so this woman was arrested. You can see the arresting officer's signature there. Shout out to Kenneth in DC on 8/19. 2 counts. 1, threats against the president and successors to the presidency. And 2, another federal charge, interstate communications with the threat to kidnap or injured. Filed, charged, arrested. The case has been progressing. And then guess what happened? Judge Boasberg, in another case, just modified the release conditions, and she is now free. And so people are saying, well, is this judge maybe giving her some special privilege because he hates Trump? Or is this pretty standard operating procedure? Let's take a look at the documents and see what's going on here. So they write here, from on or about August 2nd until August 9th, 2025, this person, the allegations against Nath Jones are that members of the United States Secret Service, are watching her. They observed Instagram user called Nath.Jones, and she was posting threatening comments about the President of the United States. This included publicly accessible Instagram posts that, among other things, 1, called for the president's removal, 2, labeled the president as a terrorist, 3, referred to the president's administration as a dictatorship, and 4, stated that the president caused extreme and unnecessary loss of life in relation to the COVID. Now, from August 6th until August 15th, so kind of a separate batch of dates with some overlap, law enforcement observed that Facebook user, also called Nath Jones, also posted threatening comments about the president. This included publicly accessible Facebook posts that, among other things, called for the administration to be removed and requesting that the president be arrested as a terrorist. Urifiant, this law enforcement officer, has included 3 specific Facebook posts from this account below. Let's take a look at them, sanitizing them as appropriate, because she's kind of nuts. FBI, she says, okay, she writes this, Nath Jones. Okay, let's say you have an elected official. Perhaps you are an American citizen even. And let's say you have rights and would like to be represented. Perhaps a place to call to the individual's office. Perhaps you make a comment on social media. Perhaps you email the office on a web form. Then, feeling unheard, you protest somehow. All right. So here's where we are. She's posted this. She says, here's where we are. I literally told FBI in 5 states today that I am willing to sacrificially eliminate this POTUS by disembowelment and removing his trachea with Liz Cheney and all the affirmation present, and you did not come to my home this way at all. The FBI didn't come. Okay, let's deal with this and restore domestic tranquility, she says. So she's like reaching out to the FBI saying that? So look, what is the limit of our First Amendment? Well, you just found out, just crossed it right there. What do you need for me to remind the Supreme Court that we will not be terrorized by leadership by invoking the Second Amendment? It's actually a threat. You can invoke the Second Amendment to defend yourself, but not to go kill someone and make actual true threats. I'm just trying to say, don't kill people en masse unnecessarily. What do you hear? Now let's finish planning this arrest and removal ceremony now. ICE knows that this country isn't going to continue with cruel and unusual punishments. Homeland knows I have to defend my AARP patients who have been terrorized and will not be induced into psychotic hysteria, we're not talking about that, nationwide to die by this administration. So please have Woodlawn Field Station for my father's family, Crispa Vendor from Indianapolis, New York City FBI for writers, San Diego FBI for guys who want to blow jobs, who want something, a CIA nationwide, but can't at all show up for marriage for real sober. She's nuts. All right, so you get it. She's just nuts. So that was one post. Here's another post from her. CIA, just find him and drag his butt out and F him up. What are you doing? National Guard. Yes, the protest is serious. And she's also referencing Liz Cheney again. So she might just be a crazy person. Now, Pete Hegseth, she also posted, please arrange the arrest and removal of POTUS as a terrorist. The National Guard will be there. And we've tried this administration, given the Supreme Court and the risk of entrusting the United States to a convicted felon. But his are not official acts of late, and it's not constitutional. And the affirmation, okay, this is a couple times she's posted about this. What is this? The affirmation is removing him with his whole line of succession, which is a weird thing because she mentioned it up here too with Liz Cheney. She said, we want to remove his trachea and disembowel him with Liz Cheney, who probably would enjoy that. And all the affirmation. What is that? All the affirmation. Is that some little liberal cabal of communists? The affirmation. Strange. Now, on or about August 15th, members of the Secret Service went and talked to her. During the interview, she said, yeah, the president's a terrorist and a Nazi. And if she had the opportunity, she tells the Secret Service, she would take his life and eliminate him at the compound if she had to. She had access, she said, to a bladed object. Okay, so it's not just also statements on the internet, which you can, like if you call, a governor and make a threat, or you call a president, call a senator, they prosecute you for those, right? Send an email. I'm going to come do something to you. She's making maybe not direct threats, but online posts. So they come talk to her. She says, yeah, no, I would do it. She explained that this was the weapon that she would use to carry out her mission of eliminating him. And she said that she wanted to avenge all the lives lost during COVID. And she said that was because of Trump and its position on the vaccines, which, what are you talking about? Is she saying the vaccines killed the people? Or Trump's in the position on the vaccines, like not getting people vaccinated quickly enough? So during the interview, she also stated that she hoped to get in touch with the 3rd United States Infantry Regiment so that the unit would arrest President Trump and peacefully remove him from his position. She also advised law enforcement that she intended, here you go, on traveling to Washington, D.C. for an event at the Carter Presidential Library and the museum, along with an unspecified demonstration in the city the next day. So then, on August 16th, members of the Secret Service observed Jones in D.C., so now they're watching her. On the same date, law enforcement conducted a second voluntary interview. What are you doing here? During this interview, she admitted that she made threats towards the president during her August interview. However, she denied having any present desire to harm the president. And so on or about August 16th, they arrested her. You can't make threats against the president, okay? It's in the code, U.S. Code, 18 Section 871. You can't make threats in interstate commerce, not allowed. Upon being, and it's not a free speech thing, upon being apprehended, Jones agreed to speak with the arresting agents. During the interview, she confirmed that she was the owner of the Facebook account called Nath Jones and that she posted the threatening statements towards the president of the United States that we just read that are horrific. So Richard, Secret Service agent Whitted Jr., shout out, sent all of that in to the judge. Now, what happened is this case has progressed a little bit, and we saw that the judge has now modified her bond and released her. And the judge who did this is Judge Boasberg. You see him right here. The same judge who ordered Trump to reverse the airplanes and bring the illegal aliens back, who then got castigated by the Supreme Court, who then ignored them and continued to prosecute Trump, is now releasing this lady. So, yeah, you're good. Not a big deal. Let's see what he did in terms of the release conditions. He says, all right, here's what she's got to do. Now, she must not violate any laws, DNA sample, let us know if you're changing your phone number or residence, must come back on this date, September 2nd, today. And this is what happened. It looks like on August 26th. Boasberg modifies this. Says defendant must sign an appearance bond, supervision, pretrial services, surrender your passport, and stay away from Washington, D.C., okay, except for courts and meetings with attorneys. She's also, got to get a psychiatric treatment, receive a mental health assessment and treatment that's directed by pretrial services, no firearms or destructive devices, may not use any narcotic drugs unless prescribed, and you must, home detention. Okay, so she's not totally free. You are restricted to your residence at all times, except for employment, education, religious services, and medical substance abuse and other things, mental health, attorney visits, court appearances, other things. So some home detention with GPS monitoring, pay all or part of the location monitoring services, and let us know if you've ever been arrested or stopped by the police, if that happens again, and verify your address. Okay, so there are some limitations on her. She's not just running free. Home detention, GPS monitoring, don't leave. Report to the 9th floor for your GPS installation. Following installation, then you can go to the program orientation. You're escorted by a member of the police to receive the property and to complete the GPS installation. And once you get that monitor on, you shall return directly to New York. So she was released, but obviously she's got some limitations on what she can do. And apparently she had a hearing today. So let's see if there's anything new that just hit the docket from, and she filed a motion to modify her release conditions. So she's going to want to probably, can I travel to my parents' house in New Jersey, right? Or something. So the minute entry, they say parties discuss the posture of the case. There's another hearing set for the 8th, in person, bond status, personal recognizance. So she is out, but she's locked down in her home. So interesting development. And, I think, depending on her criminal history, the judge, could make a discretionary judgment that direction and let her out if she's got nothing in the record. But we'll keep our eye on this one. And obviously she seems crazy. So that's also a problem because we know other crazy people or foreign agents have tried to take out the president before. So we'll keep our eye on this one. But Nath Jones now arrested, charged, locked down for making threats against Trump. Now, speaking of another threatening individual, this one's going off. Here is what's happening with Ryan Routh. The attempted Trump assassin is trying a very interesting new tactic. His trial is right around the corner. Jury selection starts in less than a week, and he's representing himself, and he submitted this motion on his own. He fired his public defenders. They're standing back and standing by at the moment in case they need to jump in on this thing. But as trial inches closer, we got Ryan Routh, who's now submitting these motions on his own. He's writing these on a typewriter from prison, and don't know that it's going to work out all that well for him. But we're going to come back to this because this is a motion to exclude the prosecutions, and he also submitted another one that we'll take a look at right here, which is a motion to admit 3 other letters. He's talking about Putin, all sorts of crazy things. So we'll come back to that, but here is a little bit of background on this fella. You remember him is this guy, and Wokeness dug this back up for us, And this guy was making statements about Ukraine, flying over there, taking pictures with them, Ukrainian flag all over his chest, and very interested in this cause. Okay, here again. We're looking for families and homes and foreign exchange volunteers. This is the guy. He also said this.
Every day in my interactions with everybody, every one of us is responsible for the outcome of this war. Every one of us, by our actions and what we do. And, when I call back home and say, hey, I need $5 so I can, put enough money together to get a vest for a Ukrainian, and I get no response, I'm like, I'm not sure that the world is as wonderful as I once thought.
All right, so he's there and talking about, we got to go fight for Ukraine, die for Ukraine, whatever. Part of the, litany that we've heard a lot about. Here is where he got arrested on the day. Remember, he was at the golf course and somebody said that they saw the sniper rifle poking through. And there's been a lot of people saying, man, the Secret Service was so amazing. They did such a good job since Trump didn't get shot. You're like, well, the dude was still in the vicinity. Trump was rounding the corner. They had just failed in Butler, Pennsylvania, where Trump actually did get shot in the head. And now there was a second one that just came down after the fact. And what we're getting here from Susan Crabtree, she's reporting, she's like the Secret Service whisperer. She said, love Fox News' Kennedy, all right? But the statement just now that President Trump must be very happy with the Secret Service detail because one of them discovered the rifle peeking through the fence doesn't comport with the majority reaction in the Secret Service community. Routh should never have been allowed to lie in wait for 10 plus hours because the Secret Service should have swept the perimeter of the golf course, which was not done. The fact that one agent spotted Routh in the bushes was very lucky, but the U.S. Secret Service shouldn't have been depending on luck. They should have upped their prevention game, especially after Butler. Multiple Secret Service sources, retired agents, and those currently on the job have repeatedly said the same. There's been virtually no consequences for anybody in the Secret Service as a result of their massive failures. Now, there's also this report. Ryan Routh had a hearing today, and we're going to go through that. The government is also submitting their witnesses and their exhibits. But here's a report from Fox News on what was happening outside the courtroom.
Fox News alert now Ryan Routh, the man accused of attempting to assassinate the president last year, is in court right now in Florida. It's his final pretrial hearing before jury selection next week, and he is apparently representing himself today. Routh is facing 5 federal charges, including attempted assassination of a major presidential candidate and a slew of weapons charges. His criminal defense attorney, here's criminal defense attorney Donna Rotuno.
Given the fact that he has this long, extensive history, a mental health history, I am quite surprised that there have been no requests here to determine his fitness to stand trial, because I think if there's ever an issue coming back in an appeals court, that may be something that is risen. And I'm surprised that the public defenders that were originally assigned to this case did not raise that issue.
Okay, let's pause on that because that was on Fox, and I think that's wrong, actually, because we've covered this case for a while now. And when we looked up whether this happened, we saw that there was a competency review. They actually did this. Back on July 10th, remember, before Ryan Routh was allowed to fire his counsel, the judge went through and really read this guy the Riot Act and said, listen, man, like you're going to, this is a big problem if you do this. And you sure? Yeah. You positive? Yes. 100%. Final answer. Yes, yes. So here, remember, Routh orally moved under oath to terminate his counsel, waive the right to counsel, and exercise his right to self-representation. So the court conducted an in-camera colloquy of the defendant, which is like a lecture, and heard from appointed counsel. Following adjournment, took a break, court reconvened the hearing in a public format, so they did this behind closed scenes in public, and made findings about the effectiveness of counsel. They said, well, your lawyers are great, you want to fire them, lawyers are great. Routh reaffirmed his desire to terminate representation and to exercise rights to self-representation. He said, I don't need to talk to any other lawyers. He said, I don't want any other request in connection with this. So then the court conducted a full Feretta hearing, which is like a full, hearing, just like letting the defendant know what the consequences of his action are. Without objection, counsel, the lawyers, here you go, submitted forensic competency for review to the court for in-camera ex parte review. Okay, it's a sealed filing, which is why we haven't seen it, which is why that attorney may have missed it, because it's sealed. But what happened is she found he's competent. Okay, like if he was not competent, then we wouldn't be having a trial right now, because he would be incompetent to stand trial. He would be insane, like an insane person. But they did an assessment, and it's sealed, but the judge got it, and the psychologists say he's fine. So we can't preclude him from criminal consequences because he is competent. So they said, all right, we looked at it, and as discussed at the hearing, all deadlines remain in effect. He's got to respond. Pending resolution of this, we'll move forward. That was back in July, right? So now we are here. So I wanted to flesh that out just because we're going to read his motions, and you're going to say, this dude's crazy. Not really. I mean, not according to the court.
So our Dana Marie McNichol is live in Fort Pierce, just outside the federal courthouse now. Dana Marie, what's the latest?
Hi, Aisha. Well, Ryan Routh, as you just mentioned, is in court right now for that last hearing. He will be taking center stage after firing those public defenders last month. So here's what we could expect for the beginning of next week's trial. Ryan Routh will be in business attire after Federal Judge Eileen Cannon ordered the shackles be removed. Prosecutors raised concerns that he might wear political clothing. Routh is expected to face challenges as his trial moves forward. Judge Cannon has ruled that Routh cannot access any classified information, citing risks to U.S. national security. Although Routh dismissed his public defenders, Judge Cannon is requiring the attorneys.
What is that? What is submitted that's classified that might be a risk to national security?
To remain on standby for Routh to help with any legal advice when needed. Now, court documents paint a picture of Routh's bizarre antics before he attempted the assassination, but a motive remains unclear. Questions remain about Routh's international ties and why he was closely tracking the president's movements with several cell phones. Back in March, President Trump called for answers.
He had 6 cell phones. That's a lot of cell phones.
That's true.
And a couple of them had some strange markings on them. So, yeah, I want to find out.
And looking ahead to next week, Aisha, jury selection begins on Monday. The judge ordered partial sequestration for that jury to prevent any outside interference from.
All right, so trial coming soon, and we'll keep our eye on it. But here is what Ryan Routh is submitting. These came into court today, September 2nd, 2025, from the guy who's representing himself, who tried to take out Trump. So this is the first motion, not a real long substantive one. Says, this is my motion to exclude the prosecution's latest evidence and support for this request. All right. Says to present new evidence 2 weeks before court when it has been almost a year for them to gather all they needed. Need I say more? It is absurd. The deadline has passed. If you would like to trade admitting evidence for my subpoena of that baboon, Donald Trump, bring that idiot on. It's a deal. If you do not want to trade for the dumb person, then give me all the others on my recent subpoena list. But, incorrectly spelled, I think a beatdown session would be more fun and entertaining for everyone. This guy is a criminal defendant in a case. He's got jury selection next week. Give me shackles and cuffs and let the old fat man give it his worst. We must beat down crime in America. Carpet is red, isn't it? No harm in blood. If I am housed at Fort Lucy, can it be in a far-off, quiet room? Can I have access to documents, phone, visitation email, and maybe a computer and printer or a fancy typewriter like this one? Some female strippers would be great too. Model parent. Or perhaps a putting green so I can work on my putting. A golf joke. A round of golf with the racist pig. He wins, he can execute me. I win, I get his job. Sorry, Hillbilly Vance. Ryan Routh, inmate. All right, you're like, Rob, that dude's totally crazy. He's nuts. Not according to the courts. All right, so he's competent to stand trial, and it sounds like he's just over it, right? So that was Ryan Routh. Here is more. We got another motion from him from the prison. Motion to admit all 3 letters, number 2. They say, Ryan says, the defendant, me, was not given an opportunity to respond to limine item number 5 on justification. As I'm sure you are aware, while one certainly cannot murder another simply because they are mental, R-word, or racist, sexist, egomaniac, selfish, greedy, power-hungry, and wish to overthrow our government, such murders should be reserved for, say, he says, Hitler, Putin, Xi, Assad, Lukashenko, Netanyahu, Maduro, Raul Castro, Erdogan, and Orban. Soon, Bukele, but not Kim yet. This guy's nuts. And all of the other selfish bastards that I forget. But Trump is a public figure, not a private citizen, so any and all discussion should always be allowed. It is not private, it is general knowledge and worldwide conversation. Hence, it does no harm in releasing all letters in their entirety. If you demand case-related specifics, then we can go line by line and extract the relevant items, certainly based on the recent ruling allowing exhibits of peacefulness and nonviolent pertinent traits, as well as a gentleness as requested. So it sounds like, I mean, they're talking about like character evidence and things like that. So he's maybe hinting at that. If the prosecution is to argue that the 4 letter and the what do we as a world need to fix letter blew from the post office across the road under the bush, one must note that every line is about gentleness, peacefulness, and nonviolent caring for humanity and our fellow man, and thus should be admitted in their entirety, saying there is no mention at all of the victim, poor pitiful Trump at all. How does one suggest they only wish to introduce the envelope and not the contents? It does not show the gentleness, peacefulness, and nonviolence. It is absurd. And I personally think any jury would be offended and extremely mad not to be given all the evidence, just because it does not suit the Trump DOJ need. Every single line in the 4 letter speaks to caring, the pertinent trait. He says, quote, maybe this is in the letter, Iranian citizens, Ukrainian people, citizens of China, North Korean, Palestinian people, Vietnam, Cameroon, Sudan, its children, Russia, Belarus, Taiwan, poor U.S. people, Indian farmers, and more. If the judge demands recent and current data on character, how much more fresh and recent does one get? The ink is not even yet dry. The second note, what do we as a world need to fix likewise, is all peaceful. He's like, my letters are peaceful. I'm talking about the poor people, poor kids. All I talk about is love and tenderness. And so those letters should be admitted for the jury to read and to understand essentially who I am. And like his character is not on trial. Like, okay, so it's not relevant to this. Like no one cares if you like care about global issues. It's not relevant to your prosecution. You don't just get to submit a bunch of stuff to puff yourself up. It's got to be relevant and helpful to the tribunal. The Dear World letter is the most stale. If the prosecution demands page 1, they should also add all of the other pages. The last page, number 12, which plainly states on line 4, the thought to, quote, shred his plane. Does the defense in every case have to argue to admit obvious evidence? That's bizarre. You may need to explain to me how an airplane and a golf course are remotely related, please. If you would like to dissect the letter to eliminate all negative words about Trump to protect his fragile childish ego, coddle that child, just skip to page 2, line 12, and the common people of China. Through page 3, the struggling kid, and making everyone's lines better, like I'm doing a good job, and stop at line 12. Back up on page 7, and none of the right, and then he's like, talk about this stuff. None of the letters have any usefulness now. The world is totally effed. And who will respond to take back our presidency and democracy? Who? Ryan Routh says, Judge, I beg of you to please subpoena every single person that had something negative to say about Ryan Routh. Oh, gosh. We've said that. and put them on the stand under oath, and let's see who lies. The more the FBI, I want to cut through all the BS and tell me to my face if I have ever wronged anyone. I say no. Bring it, please. Call them all, please. All of my exhibits speak only to peacefulness, nonviolence, and gentleness as a pertinent trait and should be admitted, please. From Ryan Routh. All right, so this is about what we expected. Okay, representing yourself is not a good idea, especially this dude's got like multiple felonies, been through this before, and probably has a lot of confidence in his abilities that is unfounded. Now, the DOJ, they're actually prosecuting him, so he can send his little screeds, but they've got a whole witness list here and a bunch of people. He wants the FBI to come in? Well, they might. We got Agent 1 here, FBI, Palm Beach. Another FBI, forensic examiner, Secret Service is coming in. Somebody named Tracy's going to be here. Sheriff's Office, all ATF is in the house. More Palm Beach, bunch of other people, other witnesses. Yeah, they're stacked. Okay, so the trial is stacked. And we also had an order from the judge, and I think this is a little bit older. The court also heard Monday. Yeah, so it's a little bit old, but it's a motion in limine. And this one is more recent. So this one came out today. Yeah, and yesterday. And she granted some additional requests of Ryan Routh. So the attorneys who are on standby, they can use laptops. They're not going to get a locked room. The standby counsel wanted a locked room. She said no. Judge said you can look at all of the normal attorney conference rooms, but your request for a locked room is denied. And this one also came out very recently. She says, this is my response to Ryan Routh's some of his motions. Says the request to seal all defense witnesses is denied. He wants an indefinite seal on the identity of the defense witnesses, but otherwise we'll grant it for now. Now, we're going to make these things public. We got them today. The request for exhibits is granted, but the United States has already given you all the documents. The request for printer access is denied as moot. You already got it. The statement in the motion regarding access to discovery is also moot. Saying, Routh, you've had access to all the discovery. And if you need anything in particular, standby counsel is on standby. And the motion for office supplies is also denied as moot. The court has given him paper copies of all public filings, including those issued before termination. He's been provided with all discovery. He's got a computer and a printer. It is thus unclear what is unresolved. What else does he want? We've given him everything. And finally, he wants fees and expenses for these other doctors. And those are granted in part and denied in part. Saying, these doctors are not permitted to testify as others, as experts. In the instant motion, it's therefore denied as to these others, but the motion is granted as to McClay, the only expert for whom payment is appropriate. And so he might have an expert witness, which will be wild to watch him use. So that is the latest. Now, what went down today at trial, at the pretrial, came out from Priscilla DeGregory over at the New York Post. She says that Routh must wear professional business attire and will be allowed to address the panelists from the podium when he questions the witnesses. He'll also be assigned court-appointed lawyers who may help if needed. If you make, the judge said today, if you make any sudden movements, marshals will take decisive and quick action to respond. Okay, so you better be careful. Her instructions came after she previously allowed a gun and ammunition to come into the courtroom. It's going to be a disabled semi-automatic automative rifle and empty magazines, 20 live rounds, and 40 shotgun shells. Now, Cannon said FBI agents must at all times be in control of the items. And she said these items will not be left unattended at any time during our trial. We got opening statements September 11th. 12 jurors, 4 alternates are on the docket. Trial's expected to take about 4 weeks. Cannon also granted his request to represent himself. She says, I strongly urge you not to make this decision. Like, do not do this. He's like, I'm doing it. All right. Last week said he can't see certain classified documents because the feds explained to her it would cause serious damage and exceptionally grave damages to the national security of the United States. What the heck? So it's got to be some foreign power who's behind him. Now, Routh, who has been cooling his heels in Miami lockup, made a bunch of bizarre requests. We read through them. And if he's convicted, might be looking at life in prison. So, strange new trial strategy to attempt to try to subpoena President Trump and kind of just sending in ranty screeds. But trial right around the corner, my friends. We'll keep our eye on this one. Thanks for subscribing and joining as we do. What a beautiful day it has been, my friends. If you're just joining us, quick recap. We covered some good ground today. We talked about the EPA and a massive win. Judge Tanya Chutkan is getting reversed bigly from the DC Circuit. We read through the decision. I thought it was a very nice one. Nice to see some sanity coming out of this court. All good stuff. And we're going to save a bunch of money. Good to see it. We also then talked about this lady, Nath Jones, who was let out of custody, but she's going to be limited to home detention with GPS monitoring. And she made some wild statements against the president, and she's being prosecuted for that aggressively. Judge Boasberg said own recognizance, no longer in custody, but she's not exactly free. So we'll see what happens there. She's probably going to get a competency evaluation, and that will answer a lot. Then we talked about Ryan Routh, his trial right around the corner. He's submitting some strange motions to try to win, and we'll see how that works out for him. But now, my friends, it is time to hear from you. And thank you for being here. And thanks for subscribing to our channel. If you haven't already done that, we would very much like to see you back here tomorrow and have you join us on the day. Hey, we got Donut and John clipping for us on the day. Man, you guys are amazing. We got some new membos coming in. Ooh, bunch of new membos, courtesy of Mock Schnell. What a beautiful day it is today. Look at this. That's a nice little robot with coffee. Let's go. Happy Monday, happy Tuesday, my friends. Rick D. What's up, Rick D? Sent this from an airplane. Says, President Trump expanded no tax on tips to cover streamers and other online creators. Really? Well, that's amazing. I guess I have to tell my tax guy. That's pretty cool. Well, thank you for the heads up, Rick D. Love it. Chubby says, okay, so the real question here is, did Chutkan know she was abusing her discretion in this case? Or is she, as a blatant non-American DEI hire, because she was born in Jamaica, just that ignorant of our rules and laws that she wasn't even aware of her ignorance? I think she's malicious, personally. I don't think it's just ignorance. It could be. Like, I think there are other judges that are probably a little bit more ignorant, like Gia Cobb, as we read yesterday. She's like, there's a huge group of people that are being traumatized. You're like, all right, Judge, you mean a class action? You mean like a class of people? You don't want to call it that, but it's anyways, like, it was insane. But Tanya, I think, is a little bit more conniving. Like, she's the sneaky one. Mock Schnell, 50 new membos. Courtesy of Mock Schnell. Thank you for doing this, Mock Schnell. 50 new membo friends. Stick around. We're going to have a great after party. Can't wait to talk to you. Donald Duvall, welcome. Kevin Murphy, Miss Monica, Pure F in Chaos is here. Suzanne, what's up, Larry? Pineapple Water, just on. We got Stephen Holloway, Mark999, Geezer Gun, Honey Badger, what's up, James Stewart? The Roso Rodriguez, Bobby the Great. We got Donna, Alex Brown, Greg Barrett, Caw Valley Crypto, Rassal Crimson. What's up, James Picorella? We got Far Isle, Michaelo, Robert Lane, WJ, Andrea Cates. What's up, Ron Hunter? Stick, 2 Eric. We got Russell Stringer. Buck Around and Find Out is here. The Warrior, Debbie Mezzi, OMG, LOL, what is here? Victor Marcano. What's up, 3 Puppy Dogs? Head to Shed, Nancy Bird, the Roz Rodriguez. We got the Alice Howard, the Clever Kitten, the Patriarchy Man, G's Leg. We got John Zimmerman, Dan Simpson, Doug, Good, Cabak, Jay, CO2 Parking, Mark Diamond, TS Now, all gifted membos, courtesy of Mock Schnell. Mock Schnell, thanks for doing that. Welcome. 50 new membos. We'll see you in the after party in just a moment. Mock Schnell, thanks again, once again. Mrs. Lucio, also a new supporter. Welcome aboard, Mrs. Lucio. We'll see you in the after party, and grab the members only stream from this morning. Mock Schnell, hey, good to see you still at it, Robert. Good to have you still here, Mike Schnell. At it with us. As usual, you are teaching the unwashed masses, of which, I consider myself, how to understand how these crazy judges continue to work. Hope things continue to go well for you and the watchers. And right back at you, Mach Schnell. We appreciate it. We have a nice little, symbiotic thing happening here. We appreciate it. Thank you for supporting us. And thanks for bringing in new membos. Amazing. Rob Stoops, what's up? What money are they using to pay these lawyers? Is it grant money? If it's the grant money, then it should be cut off and the lawyers terminated. Yeah, probably. I mean, we're probably paying for them to sue us. You get that? It's like the same thing when the FBI agents sue or when the unions sue. Okay, all the public servants have public unions and then they sue us. And where do they get their revenue? They skim off the top of the money that we give to the employees. And then they sue us with our own revenue, essentially. So yeah, it's ridiculous. Linda Walling, what's up? Thank you, Linda, for the nice dono. And for the nice cup of Joe. Appreciate you. Love that. E. Texley, hey, thrilled to see that Judge Routh wrote this decision. Before being named to the D.C. Circuit, Judge Routh was Trump's deregulation czar. Perfect. Wow, I didn't know that. That's a good detail. E. Texley, thank you for that. Yeah, I have to look up more about the dude, but it was a great decision, honestly. And he didn't mince words. He's like, Chutkan, you're dumb. Chubby, the real issue is that these judges don't give a flying hoot about being reversed nor chastised because they have no teeth. Yeah, there is no real repercussions for their blatant abuses of power. You're speaking my language, Chubby. That's why I've been going nuts here, saying Congress should do something. What is their consequence? Nothing. Until they start being repercussions, they're just going to keep pushing their activism over following the laws of our country. Just look at Boasberg as a prime example. Yeah, they're basically immunized from removal. They've got life tenure. All Congress needs to do is just, start it with one and see what happens. JP Mangan, what's up? Says, wow, $27 billion. That's a lot. Go out and buy 155 F-35 stealth fighters for that much money. They cry about how much money we spend on defense. Wow. Yeah, it's just going to greenhouse gas reduction, which I don't even know what that means. I mean, I think that they produce a lot of greenhouse gases, crying constantly about the climate. Off-label. Info come out says those. Yeah, so lots of debates about the jabs. Thank you, Off-label. Mach Schnell, what's up? Okay, so from what I could find, it cost $150 to $450 a month after setup for GPS ankle monitors. And also those appointments and places must be notified to the tracking company. Yeah, no, it's a lot. That's a lot. It's a lot to have an ankle monitor on. It's not like a convenient thing, right? It's a pain in the butt. And, in this case, it seems warranted. Mach Schnell, what's up? 10 months as a membo, says, not saying the crazy person should be out, even on GPS tracking. Just mentioning it is going to cost her about the same as a $10,000 bond. Yeah, no, she wanted to know what the limits of free speech were, and she found out. Bucky's is Rome. I saw this, man, as we were setting up this show. We'll probably watch this tomorrow morning. But scratch one narco terrorist boat. They just got a fueta. They got deported to the afterlife. Villa Plot, what's up? Tax free, tax free, tax free. Thank you, Villa Plot. It feels much better when it is tax free. I'll tell you, it hits different. Thank you for that, Villa Plot. Appreciate it. Hey, Lisa Morris. What's up, Lisa Morris? Hey, thank you, Lisa, for becoming a membo. We'll see you in the after party. YouTube friends, hang tight. We're going to share a link, and then we'll go over there and see what you have to say in our debrief. NJG Gustav says, smash that like button, my friends. Thank you, Gustav, for the reminder. And thanks for doing that, my friends. Only if your thumbs are working. If they're not working, then you have a pass. But if they're working, we'd appreciate it. Let's see what's happening over on X. And then it's after party time, baby. So let's see who's over here. Shout out to our friends on X who are watching over there. We've got some comments. Neuro D, good to see you. Nathalie Rose Jones, we've got a photo. And this one from Patriot Victory says the CIA had total control over Obama. The CIA controls both parties. Every patriot must read Destroying America, the CIA's quest to control the government. Man, that sounds like a good one. John Brennan told Congress he gave information to the FBI that served as the basis for the Russia investigation. And it sounds like a great book and a good recommendation. We got Fred Pedamonte says, this is her, Nathalie Rose Jones. He says it's in the eyes. She doesn't look like that insane, like she's going to disembowel somebody, but you never know, All right. Anyways, so hey, thank you for that, NeuroD, sharing the Rumble link. Thanks for watching on Rumble. Shout out to our Rumble friends. Very grateful for you, wherever it is you're watching. We appreciate you. And Sharpie Guy, what's up, Sharpie Guy? Says, Routh is an incompetent weirdo. Is this a new normal, Rob? Reminder to keep both eyes wide open, watchers. Well, Routh, I mean, he seems crazy, but, officially not. So trial's progressing against him. And I don't know if he's now trying to make a political statement or a political point, but, I mean, they weren't really sophisticated, whatever he was submitting there. So it's not like a, big manifesto or something like a Kaczynski or something. It's like the dude's just kind of maybe nuts. And we talk a lot about this, right? It's the law of big numbers. Like if you have a giant population, you're going to have crazy people. Even if you just say you got 1% of the people are crazy, you got a population of 1 billion people, 1% of them are crazy. And of the 1% who are actually like crazy, 1% of those people will still actively do something to it's still like 10,000 people, right? Is like the number. If it's like 1 billion people in the world, I think that's the math, but maybe more, right? It's a lot. So that you got like 10,000 crazy people who would actually do something. Yeah, they're like all running around. Maybe they're actually in the in the middle of the process of like planning something. So it's a big world, and once you think about numbers at scale like that, you start to realize it's kind of surprising we don't have more attempts. It's like, well, how come this is not happening more? Because we got a lot of people out there and a lot of crazy people. And so we're glad that we don't, obviously. So my friends, thanks for those great comments and thanks for being here. Of course, now we're going over to our members only after party. We'd love to have you come join us. We debrief for a little bit, see what you have to say about the show and what else is happening out there. Take some additional comments and we have some fun. So come join us, watchingthewatchers.locals.com, or click the join button on YouTube. You'll become a member. I'm going to drop a link to the members only stream after party coming up here in a second, and we hope to see you there. But it has been a beautiful stream, my friends. Happy Tuesday. Great to be back on our regular schedule. Membos will be back tomorrow morning with the members only stream as well. And so it's been a beautiful day. Thank you for being here. Thanks for subscribing. Thanks for all your support and love. Big shout outs to our mods who modded the fort down for us today. John and Donut and K-Bean and Carrie B. We got NeuroD, Janik, and Dog Digger, G-Gum, Elliot, and Just Rhonda helping to keep this place nice and orderly. And we appreciate all of you. Thank you for being here. We're going to pause here for the evening. Of course, we're coming back tomorrow. And in order to do it appropriately, we are going to need to see you right back here so that together with your help, we can shine that big, beautiful spotlight of accountability and transparency down upon our system with the hope of finding justice. Make it a beautiful night, my friends. Sleep very well. I'll see you right back here tomorrow. Bye-bye.
Thanks for watching, my beautiful friends. Now it's that time where the stream must end. You brought the heat with every chat and line. Together we expose corruption. One more time we dove in the truth where the media hides. Lit up the lies with receipts on all sides. The fight isn't over, but we made them sweat. We ain't done yet, no, not just yet. Because together we are watching the watchers. Truth on our side. Watching the watchers. We won't be denied. Watching the watchers. Eyes open wide. Fighting for freedom with nothing to hide. Drop a like and don't forget to share. And bring a friend who's ready to care. Tomorrow's lies are just today's news, but here we see through